What if your loved one was partially at fault in causing the accident that resulted in their death? One of the biggest misconceptions about wrongful death is that if your loved one was partly at fault, then your family has no claim. And that's simply not true. California is a comparative fault state, which means a wrongful death claim can still be brought even if your loved one was partially or even mostly responsible for what happened. For example, maybe your loved one was speeding, crossing outside a marked crosswalk, or made some other mistake that contributed to the accident. In those situations, the value of your claim may be reduced by the percentage of fault assigned to your loved one. So if a jury determined that your loved one was 20% at fault, then the family's recovery would be reduced by 20%. But here's what's important to understand. Even if your loved one was mostly at fault, a wrongful death case may still have significant value. We've recovered compensation for families even when the initial facts looked pretty bad. In one case, a man ran onto a major freeway at 3 in the morning, and in another, a bicyclist crossed multiple lanes of traffic and rode directly into the path of a car. But the issue was not whether the decedent made a mistake. The issue was whether someone else shared responsibility for causing the death of your loved one. If another person or company contributed to the death of your loved one, they are still accountable for their share of the harm they caused to you and your family.